Welcome to today's deep dive inside the courtroom, where the tension is already running high. This isn't just any case. It's one packed with shocking twists and serious stakes. At the center of it all is Bryce Thomas, a defendant now staring down a long list of felony charges. We're talking about theft of a firearm, possession of restricted weapons, and even an offense involving indecency by exposure. But here's where the story really turns heads. The weapons he's accused of stealing weren't taken from random homes or stores. According to investigators, Thomas allegedly broke into actual police patrol cars and walked away with firearms. Those stolen weapons weren't left untouched either. Reports say they were altered and converted into dangerous automatic guns. The risk that these could have landed on the streets in the wrong hands is enough to make anyone stop cold. The court isn't taking that lightly. Everyone in the room understands just how serious this could have been. The defense is expected to argue that Thomas is nothing more than a reckless young man who made foolish choices and should be given probation to turn his life around. On the other side, the state is gearing up to drive home a harsher message. Crimes of this scale demand accountability, and the community needs to see consequences. What makes this moment so gripping is the judge's stance. From the very start, it's clear excuses aren't going to fly easily here. The judge is weighing not only the facts, but also the potential danger that could have unfolded. And as the back and forth begins, you can already sense that this hearing won't be smooth sailing for the defense. Stay tuned, because this courtroom session is about to heat up fast. The arguments are sharp, the emotions are raw, and the outcome could send shockwaves well beyond these four walls. Some startling truths are about to be revealed, and you won't want to miss a moment.
Breaking into a cop's car, didn't you? That is some nerve. I mean, seriously, you're the second person I've had in 11 years that has had the nerve to do that. All right, so you're Bryce Thomas, and Mr. Thomas was previously in court, entered pleas of guilty in cause number 24, DCCR 0389 to the third-degree felony offense of prohibited weapon. Cause number 24, DCCR 0390, also a third-degree felony of possession of a prohibited weapon. Cause number 24, DCCR 0391, pled guilty to the state jail felony offense of theft of a firearm. Cause number 24, DCCR 0392, pled guilty to the lesser offense of indecency with a child by exposure, also a third-degree felony. There was no plea agreement. I have received and reviewed the pre-sentence report. Has everyone had an opportunity to review that report?
State has.
In addition, there is also the largest packet I've ever received of jail incident reports in a case. Did everyone have an opportunity to review those?
Yes, I took an evening and
35 pages.
I reviewed them one evening. Good.
State reviewed all 35 pages of the list.
In addition, the state has filed a state sentencing memorandum. Mr. Burbank, did you receive that, and were you able to review it? Okay. Anything else, any objections or corrections or additions to the report?
No, Judge.
All right, Mr. Burbank, you may proceed.
In this part of the hearing, the defense attorney works hard to steer the focus away from the crimes themselves and instead onto Bryce's youth. The argument is simple. He's young, immature, and made poor choices that shouldn't define his future forever. It's a strategy often seen in high-stakes cases, trying to convince the court that mistakes tied to age deserve leniency. The lawyer doesn't just stop there. He lays out a proposal that blends both accountability and mercy, probation with a short jail sentence attached. It's framed as a middle ground, something that punishes Bryce but still leaves room for him to grow, learn, and hopefully reform. On paper, it sounds reasonable, discipline paired with a second chance. But here's the problem. The evidence of Bryce's behavior paints a much darker picture. His long trail of jail write-ups, repeated violations, and reckless choices make it hard to believe he'll respect the strict rules probation demands. The court has to weigh whether his history shows someone capable of turning things around, or someone who simply can't stay in line. That's the tension hanging in the air. Do we give weight to the idea that youth naturally comes with mistakes and offer another chance? Or do we recognize that the risks here, especially involving weapons and public safety, are far too dangerous to excuse? It's a clash between compassion and caution, and it leaves the courtroom grappling with a question that doesn't have an easy answer.
This is a very young kid that in a very short period of time kind of jumped or stepped off the cliff and got himself in a lot of trouble. I will represent to the court when I was encased by his family. One of my issues was the recovery of the weapons because they were law enforcement weapons. I will represent to the court that almost immediately, mysteriously, weapons ended up in my office in the front hallway and were returned to the sheriff's department. And I'd like the court to take notice that those weapons were off the street and back into the department.
Could you speak up a little bit, please?
Oh, back into the department. We go open because I do not have a recommendation. You can place him on probation for a period of 10 years and see what he does. These are third-degree felonies that you can do. At the very end, state jail, Judge, I believe, the theft of the firearm. You could put him in a state jail for a period of time and put him on probation for the other one. I would ask that if you are going to send him to the penitentiary, that maybe in reference to the sexual offense, you place him on probation so that you can have some accountability for him once he got out for a period of time. That would give the court maybe whether or not he's learned his lesson. Now, as you peruse through the 35 pages of incident reports, and I'm not trying to be funny, because I've talked at length with Mr. Thomas about those, and he'd like to address the court on those. It is what it is, and that's not behavior of whether or not he would be able to follow the court's orders if he can't follow what's going on in jail for a period of time in reference to probation. I would ask that the court would ask Mr. Thomas.
And there it is, Bryce himself stepping forward with a classic young and dumb defense. He leans heavily on the idea that his age somehow softens the weight of his choices. But almost instantly, the judge pushes back. The message is blunt. When mistakes keep piling up and the same violations repeat over and over, youth stops sounding like a reason and starts looking like a pattern. This exchange underscores one of the biggest truths in criminal law. Rehabilitation can only succeed when the person at the center of it is genuinely ready to change. Saying the right words in court might sound convincing in the moment, but judges aren't easily fooled. They've seen case after case where empty promises fall apart the second real accountability begins. Without evidence of growth or effort, talk of being young loses all of its weight. What makes this moment so powerful is how it forces the courtroom, and even us as observers, to think about the balance between second chances and hard consequences. At what point do repeated missteps show that someone isn't learning at all? If you were sitting in the judge's chair, would you believe Bryce's explanation and give him another chance? Or would you see it as just another recycled excuse with no real change behind it?